Good evening, and thank you for attending our live stream on the proposed agreement between Six Nations the Grand River Elected Council and Paris Grand Estates Incorporated. I'm Peter Graham, Consultation Supervisor, and I'm joined by many of my colleagues from the Consultation and Accommodation Process Team, which operates out of the Lands and Resources Department. I'm just going to go around the table so my colleagues can introduce themselves.
Good afternoon. I'm Lonnie Bomberry, and I'm the Director of the Land Resource Department for the Six Nations Council.
Good afternoon, Don Russell. I'm the Consultation Administrative Assistant.
Good afternoon, Lauren Jones. I'm the manager of the Six Nations Wildlife and Stewardship Office.
Good afternoon, or good evening, I guess. I am Taylor Hill. I'm the Assistant Director at Lands and Resources.
Thanks. So yes, this is a 150-acre property in Paris that was previously the Paris Grand Country Club. Its address is 150 Paris Links Road. The property includes a former 18-hole golf course with a clubhouse, various small buildings, and a large lot with a house on the south side of Paris Links. There's a functioning inn on the property, which will continue serving that purpose after this development proceeds. This is an older project than we usually bring before you. The draft plan of subdivision was submitted to Brant County back in 2013 and revised in 2017, finally approved in 2021. At full build out, the subdivision will have about 750 residential units comprised of both single detached and multi-unit housing. At the end of the day, it'll depend on market conditions, whether the developer believes it'll be more profitable to have more multi-unit versus single detached. The first phase of construction is already underway, but other phases must wait until the quarry to the north of the subdivision closes. And we'll show you a map with the property shortly. So as you can see here, that's the location at 150 Gulf Links Road. As you can see, the property directly adjoins the Grand River. And you'll see right to the north of the property outlined in red, the gravel pit. And that's what the developers have to wait upon before most of the property is developed. And my apologies, it's a rather poor map, but it gives a rough idea of how the developer sees the property going forward, and it's that's the zoning that's been approved by Brant County. Lauren will walk you through some of the details of that property momentarily. And just a moment, I'm just having difficulty navigating. All right. Now, as to the proposed agreement itself, conversations with Paris Grand Estates began in 2018, and a tentative agreement was reached in 2019. In early 2020, before finalization, COVID struck, delaying those conversations. There were also further delays as the proponents retained a new lawyer, and the consultation accommodation process team insisted on an inflation clause. Under the terms of the agreement, elected council will receive $1,136 for each unit built, and that per unit rate will increase each year to keep pace with inflation. There's also a clause about employment and apprenticeship opportunities, but because construction is already began on this project, there'll be probably less opportunities for community members to take advantage of that. But certainly, if anyone knows of anyone interested, please get in touch with us. We'll have contact information front and center on the final slide. And now I will turn things over to Lauren Jones to discuss the natural environmental impacts.
Lovely, thank you. So similar to Peter in this circumstance, because of the age of this project, I will just be reviewing the ecological documents that have been provided to us. While it is generally within my job description to provide feedback and push for stronger environmental considerations, we were unfortunately unable to do that in this case due to me not being employed at the time. So for this project, an EIS was triggered due to the proximity of the Gilbert Creek provincially significant wetland. With the development providing a buffer to this wetland, and it was triggered due to GRCA policies. This Gilbert Creek PSW, provincially significant wetland, is our major priority for protection on the site. On this map, okay, I was waiting for that. It's outlined in green on the map. So this is technically a complex of wetlands and spans about 21 hectares in total. It is also considered to be a designated natural area. The ecotypes within this wetland include marsh and coniferous swamp. It's been identified as being important for waterfowl breeding as well as significant for fish spawning. Therefore, we are very concerned to protect this area. There's also a significant woodland that is identified in the southeastern section of the site. So it's kind of that lower left big green section that overlaps with the Gilbert Creek PSW. For the soils, the majority of land was classified as urban land, meaning that it is built up. There is human-based infrastructure that is there, i.e. the golf course. But the soil is considered to be overall well-draining with the exception of the wetland areas. There is some peat present in the northwest area that will be protected. There is 3 hectares of vegetative habitat to be removed in total. Unfortunately, I could not track down any numbers in particular with regards to exact number of trees removed. Of the vegetation that would be removed includes Scotch pine plantations, woodland, hedgerow, and some meadow and marsh. Notably, a non-significant wetland in the northeast will also be filled in. For assessments, 140 species of plants were observed, with 33% of that identified as non-native species. Some plant species that I noted to be of particular interest to Six Nations included black cherry, raspberry, white pine, strawberry, white cedar, and serviceberry. Invasive species observed included Norway maple, garlic mustard, and buckthorn. They did do some desktop historical studies as well that included 17 significant plant species. Of these 17, only butternut was observed on the site in 2011 with the most recent studies. 13 butternut trees were identified, 7 of which will have to be removed. For birds, 62 species were observed on site, and 97 species were observed within 10 kilometers of the site. Species of interest include Cooper's hawk, ruffed grouse, common nighthawk, bald eagle, barn swallow, and eastern meadowlark and bank swallow, in addition to some other ones that I listed on the original info sheets. Bobolink and meadowlark were noted on the northeastern edge of the property. Ruffed grouse, common nighthawk, bald eagle had no detections through the targeted surveys done in 2011. As an update, additional studies also took place in 2012 in which chimney swift were detected. However, there is no suitable nesting sites available on site. For snakes and turtles, there is a historical observation of a painted turtle, and a single deceased juvenile snapping turtle was observed in the stormwater management pond to the left of the map there, that large, kind of tall blue spot there. Okay. For Anuran calls or frogs, two areas of note. So Station 2, again, that same storm water management pond, showed a high level of American toads calling. And then on the top right, kind of the top, most top corner, sorry, I should have indicated this, was also noted for a large number of spring peepers. There was also some historical sightings of badger habitat. For this, you're looking mostly for the habitat to be present. For example, friable soils, meadows, prairies, old fields, pastures that are generally suitable for boring. They did not find any sign of badgers. They did, however, find some tracks and signs of gray squirrel, muskrat, white-tailed deer, raccoon, and coyote. No bat assessment took place in the area because of the age of the study. For fish, again, we are mostly concerned about the Gilbert Creek, which has been identified as a cold water creek. Brook trout are a cold water species that are found in the Gilbert Creek, alongside some other species, including brook stickleback, white sucker, long-nosed dace, and black-nosed dace. They did identify some spawning beds in 1998 that were close to the Grand River, and as well as found bluegill and smallmouth bass at this time. The aquatic habitat assessments in general all the water bodies, with the exception of Gilbert Creek, were classified as first order streams, meaning that their drainage area is very small. They don't receive much water from other tributaries, and so we're pretty low risk. In terms of mitigation to these environmental features, the GRCA specifically recommended a minimum of a 30-meter buffer to the provincially significant wetland watercourses, recharge zones, and surrounding all core heritage system areas. So again, essentially that entire green area that you see there. In addition, anywhere where significant woodland is present but not a PSW, a 10-meter buffer will also be instated. Where there is both, that larger 30-meter buffer will be followed. There are also some areas, the project footprint as well has been designed with these environmental limitations in mind and aims to reduce the amount of earthworks that have to take place. Legislatively required timing windows associated with bird nesting and fish spawning will also be followed. The proponent also said that they will be following and adhering to directional lighting to reduce light pollution around these natural areas, as well as some plantings to offset some of these trees coming out and reduce the encroachment into these natural areas. There's also sediment and erosion plans created. And that is all I have. Back to you.
Thank you, Lauren. I'm going to turn things over to Taylor in a moment to talk about archaeology and the survey. After Taylor's done that, I'm going to read the questions and answers that we've previously received in case that's helpful, informative to any of you before we open up the floor. Taylor?
So the archaeology was done in 2017 and 2018. I will premise this by saying I'm not the archaeology supervisor and I was not employed during that time. But so during that time, our previous archaeology supervisor was not employed. And our current archaeology supervisor was not employed, and our previous archaeology supervisor was on a sick leave. As such, there was no monitors on site, but the reports were sent over for review. So the archaeology went to stage 3. The main findings were Euro-Canadian or settler. There were 3 points or arrowheads, I guess, more commonly known found, and then the rest was like about 20 less than 30 lithics, which are like scraping pieces from different rocks. They were not found in a concentrated area. They were scattered across the whole site, so the map's still up. So as you can see, the site's fairly the size of the site. That led the archaeologists to the conclusion that it wasn't an area where the First Nations were concentrated. More of a transient area, which means that they were more moving through than not. That being said, there is significant archaeology sites around that area, and in the clearance letter from the which now is the Ministry of Multiculturalism and Citizenship, it was previously called something different, did recommend construction monitoring in case anything is unearthed during the construction of each phases, particularly because it is a golf course and they're known to be disturbed already. We are in discussions with the developers about having construction monitoring for the future phases. And as for the survey, there was a sheet that was mailed out in the beginning of May. I believe it was May 7th and May 8th to every registered mailbox, where it has a section for comments or feedback. They were also giving out at the 2 in-person sessions. Those can be handed back into our office, the Lands and Resources Department, or they can be emailed at the email provided on the screen, or if you want to phone in your comments, questions, or feedback, there's also a phone number. At the last section, there was also a more focused survey handed out. That one can also be emailed if you're interested in filling out. That one is based around money allocation. So as Peter had previously mentioned, there is 1,136 plus inflation for each unit. So the money allocation survey is a list of areas where that money could be allocated to, and then the opportunity to rank those ones as you may be wanting to have it allocated to all. We are still accepting comments and feedback until July 22nd. For it to be inputted into the report that we submitted to council. But if you still want to provide comments and feedback on that money allocation survey, that can be applied to any future or present projects that may be ongoing.
Thank you, Taylor. I'll now walk you through, the answers to the questions received. There are 32 of them, so I'll try to be as brief as possible. How do these land money agreements represent reconciliation and recovery of past injustices? These payments are for accommodation for future use of the land. Past injustices are part of the main litigation between Canada and Ontario. Can there be some acknowledgement of the history? The feedback is being shared with the developer, and a meeting is being scheduled to further discuss that issue. Are we happy with the amount? Is it a good deal? Discussions on the amount began in 2019. Since then, further information on the profit developers generate from developments has been shared with Lands and Resources, and a new strategy has been internally approved and implemented. Future requests for accommodation are much greater. For this development, an amount was tentatively agreed upon in 2019, but because of factors previously mentioned, it was never finalized until much later. What happens if we ask for more? Discussions on this agreement, again, began 2018, 2019, included in 2025. The length of time it took was caused by a number of factors, and I previously noted, COVID-19. There was also some transitions with the developers' lawyers, which really slowed things down. And as time passed, we insisted that there had to be an inflation clause in an agreement, which, if approved, would kick in next year. So any inflation that happens, in subsequent years will be, fully covered. So in other words, that per unit price will increase every subsequent year of the agreement if there is an inflation. Further, the current law in Ontario creates no obligation for developers to accommodate First Nations. That duty lies with the two crowns and the municipalities that have been delegated that responsibility, frequently by the crowns. There is also currently no enforcement for the failure of developers to accommodate. This developer has already received their approvals from Brant County to proceed with the development. Phase 1 has been completed, and the developer could carry on constructing the subsequent 6 phases without accommodating Six Nations. As the developer wasn't receptive to higher amounts, the decision was to come to amount somewhere in the middle. Is the information publicly available? Yes. Please email lrcs@sixnations.ca. That's the email address Taylor previously mentioned, and I'll return to that screen before we close out. You can also call 519-753-0665 to schedule a time, or if anyone wants to see the agreement itself, they can drop by 2498 Chiefswood Road. Recommend just phone or email us and set up an appointment. There's also much of the information is available at Six Nations Public Library. How was the per unit compensation amount arrived at? There was much discussion between Lands and Resources and the developer on the amount in the agreement. After several years, Lands and Resources told the developer it wouldn't accept any less than was tentatively agreed to in 2019, as the developer was trying to lowball us. And as mentioned, we subsequently had long dialogue and were finally successful in securing the developer's agreement to having that annual inflation clause built into the agreement. Any potential negative consequences? We generally advocate for larger buffers and more updated information, and so there are a few unknowns given the time that has passed since the initial assessments and the final project. How many units have been completed? Phase 1 was 126 units. What is this meeting for? This meeting is to explain the benefits that Six Nations of the Grand River will receive from the development if the agreement is approved. The meeting is not about stopping development. Both Ontario and Canada are pushing hard for development to continue at a faster pace. Besides legal action, which is costly in two ways, both the cost itself and the effects of an adverse decision, there's currently no effective way to prevent approvals completely. What is the payment schedule? Are the payments ongoing? The payments are to be received once each phase is complete. The legal fees will be paid if the agreement is approved and signed. Where are the archaeology findings housed? They are with the licensed archaeologist from Golder Associates Limited. Can the artifacts be collected by us? No. Under the current Ontario legislation, they are the property of the licensed archaeologist. Unfortunately, as Taylor mentioned, during the initial archaeology in 2018-19, the previous archaeology supervisor was on sick leave and didn't have monitors on site, but she did request copies of the reports. Are there affordable units? We are not aware of any designated affordable units. Are there designated Six Nations of the Grand River units? Not for this project. The CAP team is currently working on 2 projects that would have units available for Six Nations members. They will both be brought to community engagement once they're ready, hopefully later this year. What about employment development opportunities, specifically A6N? A6N is the business unit created with Aecon, one of the largest developers in the country, and Six Nations of the Grand Rivers Development Corp. Answer: there is a clause in the proposed agreement about employment and contracting opportunities for Six Nations of the Grand River members. We will speak to the developer specifically about opportunities for that Aecon Six Nations partnership. Why is the amount so little? The current law in Ontario creates no obligation for developers to accommodate First Nations. That duty lies with the two crowns. Developer had received their approvals from Brant County to proceed, and as such, that leaves elected council in a poor negotiating position. Developer could decide to end discussions and not give anything at all. Why are there limited employment opportunities? Employment opportunities are limited because construction on the project has already been underway. Is this native housing only? No, it will be open to any willing buyer. Is the property owned by Six Nations of the Grand River? No, but the land is covered in the main litigation. What were the advertising efforts? I'm not going to give you the whole list here to save time, but yeah, there were trips to many post offices to ensure that every community household received a mail out. There were also notices in Turtle Island News and Two Row Times. It was on elected council's social media app and on the radio update, as well as shared with the Six Nations library. The information sheet was posted on Six Nations the Grand River websites and also mailed to certain individuals. A meeting was also held where it was announced with individuals from several organizations, including Six Nations Polytechnic, Two Rivers, and Six Nations Development Corporation. Accessing the materials can be emailed, or the Six Nations library has copies as well. The FAQ is on Six Nations of the Grand River's website. Did they purchase the property? Yes, they have owned it since at least 2017. Will there be construction monitors on site? As Taylor mentioned, we are currently discussing this with the developer for the next phases of the project. Are Six Nations the Grand River members on the board or some structure of the development company? No. Crystal Homes is privately owned. Who keeps us in the loop? The mandate of the consultation and accommodation team is to conduct the duty to consult on behalf of Six Nations, the Grand River elected council. To the best of the team's ability, they follow up on developments and projects in the treaty areas. The two treaty areas are quite large, with 40 plus municipalities and many developers in Ontario ministries. With the size of the CAP team, it is not feasible to be up to date on all projects, but best efforts are made. Does the agreement affect the main litigation? No, it does not. There is a clause in the agreement that is explicit in that it is without prejudice to the court case. Was climate change considered? When the approvals for this project were made, there was no obligation for developers to consider climate change. Now developers have to consider it, but the focus tends to be on the impacts of the construction, not holistically in any meaningful way. Any concerns with the adjacent aggregate pit? Each phase of the housing development is dependent on the aggregate operation being completed in that area. This is to avoid any dust, noise, or other concerns from future residents. What about HDI, HCCC? They were contacted about the archaeology work. Elected council is not privy to any information on any agreements between HDI and proponents. There was a request from elected council to HCCC to have a meeting to discuss numerous topics, and it was declined. Who did Paris Grand buy the property from? The corporation bought it from the owners of the golf course that previously operated there. Last question, what is the quality of the houses? That's something we generally don't investigate. As you might be able to appreciate, there's a lot of environmental and other factors that we center on. All municipalities have bylaws ensuring adequate building construction practices. But an eyeball look, they basically seem to be vaguely the same design and quality that we're seeing in most subdivisions in the area. And so those are responses to previously submitted questions. We'll now open up the floor to questions and comments from you. And we're still going to allow more time to see if some questions or comments popped up. I'm just going to move it back to that final PowerPoint screen so you'll have our contact information readily available. All right, we still haven't received any questions or comments, but I'm going to give it another couple minutes in case we hear something.
Okay, looks like we do have a question. How is the environment being taken care of for the wildlife other than a buffer zone and low light pollution? Thank you for the question. So as I mentioned, generally speaking, we do try to advocate for larger larger protections for wildlife and the general ecosystem to bring that more up to an Indigenous perspective of what is actually considered protection. As mentioned, we weren't around during this time. So unfortunately, that is the grand scheme of things. However, I do want to point out that there will be some plantings taking place as well to try and prevent the encroachment of that new development onto the existing natural space, and in an effort to offset some of that environmental impact. I hope that helps. I've also been told to tell you that GRCA did have input on this project at the time as well. This is important to note because at this time, conservation authorities did have some measure of power in terms of providing feedback for the protection of the environment. This is not so much the case these days, but we're fortunate to have GRCA have that opportunity when it was being done. Thanks.
Another question. Does this development stop here, or are there going to be a trend now?
Yeah, but both difficult and easy to answer. Yeah, I mean, they're definitely gonna. It's definitely a trend. Development's going to continue. Unfortunately, the last years there's been a bunch of awful legislation from the provincial government, which elected council has strongly opposed, eating away at basic rights and protections for endangered species. uh, just trying to find loopholes to limit environmental studies, First Nation consultation. The motto from the province is very much build, build, build. They're now even looking at special project areas that'll be designated and won't have the basic limited protections otherwise available. And you might have heard, recently on the federal level, there's similar legislation with also these project zones. They're not so much geared to residential, but we'll see. But back again to the provincial governments. Yeah, they're prepared to sacrifice basic First Nation rights and environmental protections to speed up development. So, unfortunately, I think you can say it's a trend. It's been the same trend we've seen by decades in past decades, but the government's doing its damnedest to accelerate things.
Another question, do we have any say in future developments, or is that up to the developer, like in this case?
Lonnie, do you want to talk about the kind of strategy that you want to be taking more with Ontario and municipalities?
Yes, just a little bit of background. We in our main litigation, we've had the three of Canada's aged witnesses testify, starting in August of last year and ending in February this year. And in my opinion, what becomes fairly obvious is the Halban track, for the most part, was taken by fraudulent means. So the question is, uh, you know, can the Crown benefit from its actions in taking, cheating the Six Nations of its land and the money? So, that's a big question that's going to be uh, hopefully be answered by the courts. But, so I say that we're looking at, taking a more proactive stance on these developments because, especially in the Halban, of course, in the Halban track, we had the big area, the Nanfan area, tree area, but that was made in 1701 and under totally different circumstances than the Halban track. Halban Proclamation, the result of our being allies of the British Crown during the American Revolutionary War. So it is and then to have that land given to you and then taken away from you within 50 years by fraudulent means is certainly something that always burns in my mind that there should be justice in that some way. So we are looking at ways of being more proactive and perhaps starting court actions on these things. As Peter has mentioned, it is costly, it is time consuming to do that, and we still have our main litigation to concentrate on, which is a huge case, and we tend to put all our time and effort into that case. But it's not saying that we won't look at these other ones too, because it is a concern of mine that, as Peter has mentioned, that the province has taken this attitude of build, build as fast as we can, and not only in the Greater Toronto area, but also in mine in the Alban track as well. So we're going to have to keep on top of it and pick our projects wisely.
All right, so I'll give last call, wait another minute, see if there's any more questions or comments, and then we'll close for the evening.
Was that land fraudulently given to, say, farmers for food supply? I see a lot of farmers selling off hundreds of hectares of land right now that should be given back to us, in my opinion.
Well, in the days when the lands were taken back in the 1840s, 1830s, 1850s, of course, farming was a lot different back in those days. Uh, so, you know, it predominantly were subsistence farming that occurred back in those days. Now the farming situation is totally different. It's all, in my opinion, it's all cash cropping for the most part. You know, they grow foods that generally the population can't eat, but it's food that's used in industrial uh, food production or shipped overseas for profit. So uh, it is it wasn't originally yes it was cleared for farming and it was taken back in the 1840s, but it's been out of possession out of Six Nations possession now since for 200 over 200 years or more, and successive people have owned various sections of the Halban track over those 200 years, and what they do with the property is. Is up to their prerogative because they do get it under fee simple ownership. So it isn't something that presently is going on, taken for food presently, or it's been out of our possession for so long that we really don't have much of a say on how they use the land now, other than, you know, we're going to be looking at trying to attack developments and make sure that our interests in the lands are somehow being accommodated for. So I hope that explains it. I mean, originally, as I said, it was for farming, but that's 200 years ago, and successive owners have owned various parts of the Holman tract since then. So that doesn't really apply to today's situation.
All right, we'll wait another minute, see if anything else arises. All right, we're not seeing any further comments or questions. Just want to reiterate what Taylor's saying. There's still opportunity to do a survey and fill it in as long as it gets to us by July 22nd. So please contact us at 519-753-0665 or email lrcs at sixnations.ca. I'd also note if there's unrelated developments you know about, you're concerned about, you have questions about, please also get in touch. We'd be happy to talk with you, find out information, work together on a resolution. Thanks again for attending, and have a good night.